Thank you very much. We just needed a minute there to change that presentation. I'm going to be speaking in English, but I'm going to provide a Russian presentation. So I'm Donald Taunsen. I'm the IPR attaché to the former Soviet Union, or Russia CIS in Georgia. And I'm going to be talking first about internet piracy and then about our program in general, what we're doing in the region. So history of ISP liability in the US, I want to start off with that. We had a very big internet piracy problem in the United States. Actually, our file sharing software was developed in the United States. We had some pretty big file sharing sites, and we didn't have a law to address those sites. In fact, in the 1990s, we had a very big case of a website called Napster, and Napster provided a file sharing platform. They profited by users uploading files that they claimed were not theirs, something going on still today in many countries, including here. And there was legal uncertainty about about the legitimacy and legality of these sites. This led to the need for uniform rules that applied to the ISPs that did not know or have reason to know of the infringing activity. Some sites truly did not know and should not be liable for the infringement. However, many sites facilitate the infringement in the United States, along with Europe, most of the modern economies of this world, including Japan, where I used to work, Korea, which is very much improved, and Canada, Australia, etc., have now put into effect laws that fight this kind of piracy. The ISPs themselves, in fact, asked for legislation to address the liability so that they would not have liability for things that they were really not responsible for. In 1993, you'll see a case there, Playboy versus Frena. I'm sure a lot of people know who Playboy is, and RTC versus Netcom. Accordingly, after these cases were tried in court, and there wasn't really a U.S. law to address them, the U.S. passed a very historic law called, the Digital Millennium Copyright Act, DMCA. It certainly isn't perfect. We have a lot of trouble with it, but it was enacted in 1998, and it attempts to limit the liability of non-guilty actors, but allow liability for sites that encourage and profit from piracy. The law is written in that it provides safe harbors for sites that fall under, that do these certain things, these safe harbors, which is transitory digital network communication, system caching, some technical terms, but essentially an ISP, a website, is free from liability when it is not free from liability, when it has actual knowledge that the material is infringing. For example, are the pirate sites on the notorious markets list, which I'll mention in a minute, or is or should be aware of the facts from which infringement is apparent. Once the ISP obtains this knowledge, it must remove or disable access to the material, or the ISP receives direct financial benefit from this. For example, if the ISP is allowing others to upload known infringing content and sell advertising and profit from advertising through sometimes their own network, advertising networks, then they are not free from liability under our laws. And we will criminally prosecute them as well as civilly prosecute them. There's two types of liability in the US. There's direct liability, where the pirater themselves is actually doing the infringing act. And we have a theory called secondary liability. That is when there's liability for authorizing or somehow contributing to an infringing act. Like, for example, having a platform, a website, that enables users to upload content which they know is infringing, which they know they don't have licenses for, over and over and over again, and they sell the advertising and profit from the advertising, and users can download it for free. That is infringing in the United States. That's a concept that as I travel throughout the region, I try to make clear to people that because you didn't upload it doesn't mean that you're not responsible for the infringement. You're profiting from the infringement. ISPs may also be indirect infringers in which they're held secondarily liable for the infringing acts of users or their networks or services. Well, we have a very famous site in Russia called VK, Vkontakte, who's on the notorious markets list. They are an infringer. They provide a platform for infringement, and they know the content uploaded and shared as infringing, and they profit from the advertising provided thereon. We also have a very famous website, which I'm sure everybody is aware of here, ex.ua. They are a famous notorious markets pirater. They profit from the infringing acts. They upload it themselves, but they claim that they don't. And they profit tremendously from the advertising. In fact, they own many of the advertising networks. So that under US law and under European law and under TRIPS is a violation, and under the EU Association Agreement as well. So a little talk about the history of that in the United States. We have a very famous case called MGM versus Grokster, and that was one of the first cases, and the lower courts held that the distributors of this particular software that enabled people to upload infringing content made that website liable for the infringement because they were profiting from it. They were intentionally providing the platform for infringement. And there was a court analysis of why that infringement was inducing infringement. That's what we say in the United States in our law, inducing infringement. You are encouraging another to infringe knowingly. The Supreme Court of the United States, and that's our highest court, there's no appeals therefrom. That's the final decision. They found unmistakable and unequivocal evidence that the distributors of Grokster and Morpheus software intended to induce infringement. In those days, they actually distributed software. Now you don't need to do that. It's all in the cloud. So the Grokster inducement analysis is still used in the United States, and that analysis, that legal analysis, is used to analyze whether a pirate site. Almost all infringement now is online. There's very little optical disc infringement anymore. It is used by the courts to analyze what is truly infringing content. Some people have claimed, oh, well, YouTube is infringing. Well, YouTube is not infringing because YouTube has put into place filtering software that takes the infringing content down. And they actually have a system called Content ID that the rights holders themselves can authorize the upload of the content, and then they receive the advertising revenue from that content. So if you see some content on YouTube that you think is infringing, it's either the rights holders, it slipped through the filter and the rights holders have not notified them yet, or the rights holders themselves have authorized that and they're receiving a proportion of that advertising revenue. So there's quite a difference between a pirate site and a site that tries to keep down the content. It puts in place filters and excludes that. They fall under our safe harbor provisions. So that is the end of this, and I just wanted to give you a short presentation on our program, which that's actually in Russian as well. I have it in Russian and English, but you can put up the Russian version.
Sorry, may I ask you? Donald?
Yes.
Okay. In Ukraine, we are going to integrate the same system as CDMA. So, but we have other trouble. What we should do with piracy sites which are situated not in Ukraine? What should we do? And what should we do with torrent networks?
Well, actually, pirate sites that are not situated in Ukraine.
Physically not situated.
Well, actually, those are not a Ukrainian issue then. That's an issue for the country in which they're they're situated, and we deal with those other countries. So the rights holders bring complaints to the local authorities in those countries. Now, nowadays, the piraters, they spread their operation out. So they don't have their operation in just one country anymore, very rarely. They usually have their servers in one country, their ad network in another, their bank account in another, and we work with all the enforcement officials of those different countries to track all those different assets. But that's not something that the Ukrainian officials have to worry about. Thank you.
But this site communicates Ukrainian intellectual property to Ukrainian users.
Oh, well, then the Ukrainian rights holder and the Ukrainian government, the Ukrainian government will probably assist the Ukrainian right holders. They have to research where those things are taking place and bring actions in each of the individual countries. That's what U.S. rights holders do. It's very time-consuming and difficult, but it's the only option.
Okay, thanks.
I actually work on that issue all the time. It's sometimes 4 or 5 countries. I'm going to move on to the next. Okay. 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 Sure. Thank you. Yes.
Only if I can, I'd like to ask you one question about problems that United States face with internet piracy, because we're looking close on the DMCA. We're trying to implement this, but how does United States gonna deal with the problem that today, with all these cases that you got with DMCA, piracy level in US is nearly 20%. Multiplying to the value of the market, it's much more than all over the world. And also, why is it a piracy problem that SOPA Act has failed?
You have like 3 different questions in that one question. You've got to give me one question.
I'm going to summarize it.
No, just give me one question.
How today United States is going to face this problem? Are there some new acts that you are expecting in your country?
Well, we are actually still working with DMCA, but we see that there's flaws in the system because the criminals, they always change their plan much quicker than the authorities. We see that they're spreading out their operations around the world. In fact, we were working on the mega upload case. Mr. .com was smart enough to spread his assets around the world, but eventually we tracked all those assets and we had him arrested, and he will be extradited soon back to the United States. But it's not a battle that you win; it's a battle that you continue to fight. So I don't have an answer for you to say, this is what we do to crush internet piracy. They just open a new site. You just have to keep chasing them, and you have to keep extracting the money flow and the assets from them to remove the enticement to do it. But I don't think that you can just say, hey, if we pass this particular law, like some of the very restrictive laws in say in Russia, where you think it might be a great law, but it's used for other purposes, not internet piracy. The U.S. government is not a proponent of overarching law that can be used for political constraint. Let's put it that way.
Thank you.
Can you have one more small question? Thank you. BitTorrents and other web resources can be used not only for sharing of the illegal content, but also for sharing of legal content. And I'm not sure that part of illegal content is more than legal content. And my question is, how you believe you can divide sharing of legal content from sharing of illegal content? And will it cause a kind of cancellation of privacy of correspondence in this?
I don't deal with the technical aspects of that. We don't discourage the
privacy
sharing
of correspondence is not a technical question.
Well, actually,
it's completely legal.
The sharing of legal content, we are not opposed to that. We are only opposed to the sharing of illegal content of non-licensed.
How you can see that content is illegal without opening of this content? So the content is archived.
Well, obviously you can first of all ask the rights, the big infringing sites like ex.ua, for example.
I use it as an email, service.
But actually you represent ex.ua. And so you
Present the law,
so you understand that no American movie on ex.ua is licensed. I can tell everybody that, right? Not one US Hollywood movie is licensed on ex.ua. Not one song on ex.ua is licensed. And I can go into that debate with you later, so I'm going to move on now. So I want to give a little note about the US IPR attaché program. Oops. This isn't moving. It's working now. Thank you. So the U.S. government believes that IP rights are very important for the economic development of a country, and therefore the U.S. government spent a lot of money in developing this IPR attaché program. I'm one of the 11 current IPR attachés around the world. It was just instituted in 2006, and I'm only the second one to come to this part of the world. We're mostly attorneys. I happen to be a patent attorney, but we have copyright and trademark attorneys as well. I now specialize in copyright in this part of the world. I'm based in Moscow, but travel throughout the whole region. I frequently come to Ukraine nowadays. We work with the regional governments in all of these countries, and we meet with all the industry stakeholders and the IP offices to promote intellectual property. And importantly, we believe that enforcement of intellectual property is just as important as the protection of intellectual property. So what's a patent worth, or a copyright worth, or a trademark worth if you can't enforce it? It's worth nothing. So we address both protection and enforcement of intellectual property, and that requires us to interface with both the national IP offices, but more importantly with the police and the legislature to develop laws that meet the standards of intellectual property worldwide. I come from the U.S. Patent and Trademark Office, but I work closely with the U.S. Trade Representative, and I report actually directly to the White House, and I'm based inside the U.S. Embassy. I meet regularly with big companies and hear their problems and go to the host government with their problems. And in fact, I even meet with inventors and rights holders that are not even from the United States and are individuals. I also conduct training around the region. In fact, I'm going to be conducting a training next week, a regional training in Georgia, and then a regional training in Kazakhstan the week after. One of the things that we do is we work with the U.S. government on what's called action plans. In this region, we currently have an action plan with Russia, which was signed in 2012, and with the Ukraine, which was signed in 2010. Those action plans are available online, actually, at ustr.gov. And what they are is a brief agreement that says what the two countries agree to better enforce and protect intellectual property. The US, Russia, and Ukraine have agreed to increase the level of IP enforcement in particular. And we've worked on conducting enforcement actions against counterfeiting, which happens to be a very big problem in the Central Asia where I work frequently. Counterfeit products, hard goods coming from China. They're almost all produced in China. And they're smuggled into the customs union CIS area. Piracy, including software piracy and unauthorized camcording, and the circumvention of technological protection measures, and encouraging the imposition of penalties and sentences that deter further violations. There's some law in this region that has penalties so small that paying the fine, paying the penalties is simply a cost of doing business to the counterfeiters and pirators, and we're working with the local governments to change that. Here's an example of something that's in our enforcement provision in the action plans. And actually, we're working with the EU delegation now, with the European Union, because Ukraine has just recently signed the association agreement. they are working on the same things, and we're actually working together now with Ukraine to fight the criminals who are infringing the rights of the legal right holders. So one of the things that we've done is conduct unannounced raids of plants, retail outlets, and warehouses to detect, seize, and where appropriate, destroy goods that violate intellectual property rights. Nowadays, that has a lot to do with the means of production. And then sadly, in this country, it has to do with things like counterfeit pharmaceuticals, with fake drugs that they sell people that actually have poison in them and sometimes kill people. In Russia, there was a very sad case recently of the counterfeiters actually being able to sneak counterfeit children's cancer medicine into the legitimate supply chain. They then sold that on to the Russian government, actually, the health ministry, and were able to put that into children's cancer clinics, and a high number of children actually died before they realized that these bottles of children's cancer medicine were actually just bottles of water. A very sad case, and we have worked with the Russian government on raiding those operations and arresting those people. We also work on public awareness of intellectual property and promoting the idea that IPR is worth protecting for your country. It's not something that's just for a company to profit from. It actually attracts investment. And here's a couple more examples. We've increased the frequency of open-air market inspections for things like counterfeit trademarked goods. Counterfeit, actually, in this region, you'd be surprised. I actually go to the counterfeit markets myself, and we find a huge number of counterfeit shampoo, counterfeit soap, counterfeit home products, cosmetics, and of course, they don't make them with the proper ingredients. They're full of bacteria, and I should warn you, the packaging is perfect. Sometimes the packaging is better than the original. I was shocked to see that. The Chinese have really upped their game. And we actually work with the Chinese customs authorities and police on that as well. But it's a very large problem, and it's not something you beat overnight, so we continue to work on that. Another thing that we work on is modifying the portfolios of say, MVD, the Interior Ministry, to include IP enforcement. In this region, there's a lot of other things to worry about. Frankly, in Ukraine, there's a lot of other things to worry about right now. But around the region, we are working on having police focus on IPR violations. I just talked a little bit about this, the regional IPR concerns in this region. The one big thing is counterfeit goods. You probably don't see it as openly here as you would, say, in Kazakhstan or Kyrgyzstan, where they have outdoor wholesale counterfeit goods markets that are as big as a city, 100,000 people working there. You may see it in 7-kilometer market outside of Odessa. That's pretty large, but not as big as Dordoy. We work with customs and rights holders to do trainings. Sometimes, like next week, I'm bringing in the rights holders of a bunch of companies. They put out the fake product on the table, the real product on the table, and teach the customs agents how to tell the difference. Very hard, by the way. In fact, we have a Viagra test, and I've never seen one person pick the right Viagra yet. So be very careful if you buy a Viagra online. Don't ever buy it online. It's all fake. And the last point was internet piracy. That's a problem that I just discussed, and that's a problem that we're working with the Ukrainian government right now on passing a law and then increasing enforcement against internet piracy. And like I just answered the gentleman over there, we are not against at all the sharing of legal content or the sharing of files, as long as the rights holders have given license or permission to use those files. We have no problem with that. We only care about the illegal use or the illegal procurement and benefit to pirators from pirated content. Thank you very much.